Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 18 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we're covering cases decided between October 14th, 2020 and October 20th, 2020. We will start this week with several civil litigation cases. The case of Madden versus Public School Employees Retirement Board, or the PSERB, deals with what is considered good cause for failure to appear at a hearing. Here, Madden had sought a hearing with the PSERB. He initially appeared pro se and requested a continuance to obtain counsel. He was advised that if he did not have counsel, there would be no further continuances. Madden was given approximately 4 months to obtain counsel. Shortly prior to the hearing, counsel entered his appearance on Madden's behalf and requested a continuance of the hearing as his wife was having hip replacement surgery and he needed to be available to assist her. The hearing examiner denied his request for a continuance. Madden then filed a pro se request to continue, outlining the efforts he had made to obtain counsel and that his mother was having open heart surgery on the same day as the hearing. The surgery had been moved up due to emergent circumstances. The hearing officer again denied Madden's request. Neither Madden nor Madden's counsel appeared on his behalf for the hearing. The hearing officer dismissed Madden's claim. This appeal followed. The law states that whenever a claimant fails to appear, either in person or through counsel, for a scheduled hearing without good cause, the hearing examiner will issue a recommendation to dismiss the case without considering the merits of the claim. Good cause is established when claimant's actions are justified or reasonable under the circumstances. The Commonwealth Court stated that they could not conclude that it was unreasonable for claimant to believe that counsel's unavailability, coupled with the emergent change to his mother's open heart surgery, was good cause not to attend the hearing. Therefore, finding that good cause existed justifying claimant's failure to appear, the board's order dismissing the claim is reversed. In the case of Calabretta versus Guidi homes, the homeowners brought suit against Guidi for construction defects and related claims. Guidi filed a motion for summary judgment, raising, among other issues, that the action was barred by the statute of repose, which finds that cases must be brought within 12 years. One of the elements for a statute of repose defense is that the homes were constructed lawfully. The trial court found that it could not rule on the statute of repose defense because there was a factual dispute as to what it meant to be constructed lawfully. The builder filed this appeal, claiming that while the order on the summary judgment was not final because it did not dispose of all the issues, the issue of the statute of repose was a collateral issue, giving right to immediate appeal. The Superior Court found that the issue of the legality of the construction was a factual issue, non-severable from the underlying claims, and therefore not ripe for appeal. It further stated that their finding was consistent with precedent recognizing that the collateral order doctrine should be narrowly construed so as to avoid undue corroding of the final order rule. As such, the appeal is quashed. In State Farm versus Kitko, the court addresses beneficiaries to a life insurance policy in a probate case. Decedent was married to his wife when he purchased his life insurance policy. His wife was named as the primary beneficiary. At some point later, decedent added his brother as a secondary beneficiary. In February of 2018, decedent and his wife divorced. Decedent contacted State Farm and advised the agent that he wished to keep his now ex-wife as the beneficiary on the policy despite the divorce. The agent advised him that there was nothing else that he needed to do or sign and that his ex-wife would remain primary beneficiary. Decedent received a notice that due to probate law, divorce could impair the ability of his ex-wife to receive the payout unless certain conditions were met. As he believed that she was the beneficiary, and based on what he was told by the agent, he did nothing. Decedent died in October of 2018, and both his ex-wife and his brother made a claim for the life insurance. Brother argued that he was entitled to the policy as there was no written designation renaming ex-wife as the beneficiary after the divorce. Ex-wife argued that she was entitled to the policy because though it was not written, there was an oral designation. The trial court found in favor of the brother. On appeal, the Superior Court found that a designation could be either oral or written. They also found that State Farm's policy required a written designation. However, the court found that the decedent substantially complied with the policy and therefore ex-wife is entitled to the insurance. In the case of Sampathkumar versus Chase Home Finance, Sampathkumar, who we will refer to as the appellant, and Chase had a lengthy litigation history. This instant appeal arose following a bifurcated trial, meaning in this case that the jury decided part of the claim and the judge decided another part of the claim. The jury found in favor of Chase on September 20th, and the court did not issue their decision until the end of October. Following the judge's decision, the appellant filed a post-sentence motion. The preliminary issue in this matter is whether the post-sentence motion was timely. The court found that when you have a bifurcated trial, the decision is not final until all parts of the matter have been resolved. The post-sentence motion was timely because it was properly filed after the judge rendered his opinion. The appellant raised several issues in the post-sentence motion, but only as they related to the judge's verdict. They did not raise any issues regarding an August 18th pretrial order. Because those issues were not raised in the post-sentence motion, they are waived for purposes of appeal. The portions of the appeal that were not properly preserved are quashed. However, the court proceeds to analyze and rule on each of the issues, finding in favor of Chase, the verdict winner in both the jury matter and the matter decided by the judge on every issue. The first issue raised involved a denial to extend the discovery deadline. The court found that the appellant had ample time and opportunity to complete discovery and found that the court did not act with manifest unreasonableness, partiality, prejudice or bias, or ill will. That claim, if it had been properly preserved, would fail. The second issue involved a trial court order excluding all appellant's experts. The court found that appellants did not provide expert reports in a timely manner, and the court disfavors trial by ambush. The court finds no abuse of discretion by the trial court in denying the appellant's experts. Again, this issue is not properly preserved, but the court again finds that this claim fails. The appellant also raised a claim that the trial court erred by granting summary judgment in favor of Chase on a continuing trespass claim. The court found that appellants failed to raise any genuine issue of material fact regarding the disposition of their continuing trespass claim, and therefore summary judgment was proper. In the final issue, the appellants argued that the trial court erred in granting summary judgment on their claim of civil conspiracy as to conversion. The court found that summary judgment was again proper because with no predicate cause of action, meaning some overt act done in pursuit of common purpose or design and actual legal damage result, the civil conspiracy claim must fail as a matter of law. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back. We will pick up the second half of our show with a couple of criminal cases. Commonwealth v. Gross is an appeal brought by the defendant following a conviction at trial for first-degree murder and aggravated assault. The defendant shot and killed his uncle. Upon arriving at the scene, the officer administered a portable breath test which rendered a result of .213 blood alcohol content. The defendant also spoke to the detective regarding a prior sexual assault of which the defendant was a victim. The Commonwealth filed a motion in limine to preclude the evidence of the PBT as well as any mention of the prior sexual assault. The trial court granted the motion. This decision is the basis of the appeal. The Superior Court found that the trial court did not abuse its discretion by excluding the two pieces of evidence. In regards to the portable breath test, case law is well established that the result from a PBT is not admissible at trial, and there was no evidence presented at trial sufficient to establish its admissibility. In regards to the sexual assault evidence, the court found that it was proper to exclude the evidence because though it carried some probative value, that value was outweighed by risk of confusing the jury, which is a proper basis for excluding evidence. Commonwealth v. Santana is a case addressing the ex post facto applicability of SORNA. In 1983, the defendant was convicted of rape in New York State. At that time, there were no registration requirements in New York or Pennsylvania. The New York sex offender registration law took effect in 1996. The defendant was paroled in 2000 and was ordered to register as a sex offender under New York's registration laws. Defendant moved to Pennsylvania in 2015, 3 years after SORNA took effect. He initially registered as a sex offender in Pennsylvania because he believed that he was required to do so. In 2017, he failed to update some of his registration data in a timely manner. He pled guilty and was sentenced to a sentence of incarceration on July 18, 2017. The very next day, the Muniz case was decided, which determined that ex post facto application of the SORNA requirements was unconstitutional. The defendant immediately filed a post-sentence motion to withdraw his guilty plea. In this case, because the defendant committed his offense prior to the enactment of SORNA, the application of SORNA to his sentence is unconstitutional. The court found that Pennsylvania impermissibly penalized the defendant under SORNA's registration requirement for a crime that predated SORNA by 30 years. The ex post facto clause of the Pennsylvania Constitution forbids this action. Accordingly, he had no obligation to comply with SORNA requirements and therefore cannot be penalized for failure to comply. The judgment of sentence is reversed and the defendant is discharged from custody. Our final case for the week is a family law case. DQ versus KK and JM is a custody case where maternal grandmother is seeking custody of the 3 minor children following a finding of dependency and placement in foster care. Both mother and father are drug users who have tested and continue to test positive for methamphetamines. The trial court denied the request for custody based on both an evaluation of all the factors to be considered when determining custody placement, as well as a failure to properly file a request to transfer to New Hampshire, where grandmother currently resides. The Superior Court affirmed the opinion of the trial court, finding that the trial court properly evaluated each of the factors to be considered, and it was proper to require the proper transfer request. Of note, the petition was dismissed without prejudice, meaning that if mother files for the appropriate interstate transfer, she can again petition for custody. That's all we have for this week. Thank you as always for joining us, and have a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.